It's a well-known fact that trials of criminal cases are not permitted by the accused to proceed further easily, and a trial of a criminal case takes anything up to 6.5 years to start with. One major reason for this state of affair is that the moment the process is issued, from then, at every stage, every trial lands into High Court, and order of the lower court is invariably assailed by the litigants, and the High Court, having flooded itself with such petitions in the form of either revision or under Section 482 under Article 226 or 227, the High Courts would take any number of years in deciding the petitions on their fate of the trials or whatever the stage at which the accused has come as a petitioner to the High Court. And then High Courts usually tend to stay the proceedings of the lower courts without giving a proper hearing. This is what the stumbling block for the lower judiciary in expediting the cases in terms of the verdicts, because the blockade for the trial is getting created at the writ jurisdiction level or at revision level, and that block also is happening in a mechanical manner, in a routine manner. Much of the cases which even can't see the light of the trial are for the reason that high courts have indulged in giving stays in several cases where trials are yet to begin. Legislature, looking at this state of affairs, enacted provisions that interlocutory orders cannot be the subject matter of revision petitions, and also a petition under Section 482 of CrPC would also not lie for the cases where the trials are yet to start. But the litigants and their advisors tend to file petitions that challenge every order till the time the trial starts. The accused tend to take the advantage of delaying the trial in whatever manner he can with the help of his legal advisors. At each and every time, at each and every stage, the lower court orders gets assailed by way of either revision or by triggering the writ jurisdiction under camouflaged manner under Article 227 of the Constitution, and the result would be the same, that proceedings before the trial court shall not proceed. Of course, this practice has to stop somewhere. Here, there must be awareness campaign that should be taken up on priority basis in training the high court judges or in training the lower court judges or in infusing the ethics in the minds of those litigants that stalling the trial for flimsy reasons and in a mechanical manner may not augur well for the accused, and that at the end, when the accused really gets convicted, at that point of time, either the penalty should be made heavy or the sentencing should be increased substantially. Only then some kind of fear will emerge for the unscrupulous litigants who tend to delay the trials in the lower courts by unnecessarily litigating at every stage, either by triggering the revision jurisdiction or by triggering the writ jurisdiction of the higher courts. However, it is a settled law that supervisory jurisdiction conferred on the High Court under Article 227 of the Constitution is confined only to whether an inferior court or tribunal has acted within its limits, and the jurisdiction of the High Court is not to correct an error apparent on the face of record, much less an error of law, in using its supervisory power under Article 227 of the Constitution. High Court does not act as an appellate court under Article 227 of the Constitution, and it is not permissible for a High Court on a petition filed under Article 227 of the Constitution to review or weigh the evidence upon which inferior court or tribunal passed the order, or to see to if it committed an error of law in decision. So there, in every revision against the order of the lower court, and in every petition under Section 482 CrPC under Article 227 of the Constitution, the only grievance of the accused tend to be is that and that the case was not made out, and that the charge has been wrongly framed, and that the alleged offences was not made out, and that the process was issued without the application of the mind, and that the charges framed against the accused and the prayer made in the complaint should be set aside and accused should be discharged. This is the only aim of all the criminal revision petitions under Section 397, and after that under Section 482 of CrPC under Article 227. The Honorable Supreme Court, in umpteen number of verdicts, clearly stated that the higher courts should not indulge themselves on reappreciating the evidence of the accused in pretrial stage cases under Section 482 CrPC under Article 227, because the Supreme Court has set precedents that whenever in a criminal case where the trial has yet to begin, the court's responsibility is to look at the complainant's complaint copy, and that complaint copy has to be read once in toto, and after reading that complaint copy, if the complaint copy even remotely doesn't specify any allegations which are criminal in nature, only then a relief may be given to the accused. But when an accused under the cloak of Section 482 under Article 227 taps the higher court even after losing his revision petition under Section 397 for the purpose of delaying the trial, then it's not for the High Court to appreciate the evidence provided by the accused and go in depth into the papers, unless the case is of such an exceptional nature where the principles of justice laid down and where the process of CrPC is entirely ignored by the lower court while issuing the process. Hope the information is quite useful to you all. Thank you very much.